Nigga kill over a bitch, but let a rat keep his wife.
In writing, which I've conveyed to my client. I've spoken with the state as well. At this point in time, we are declining their offer in case we further notice as a result, but per discussions with the state, we would like to be able to keep negotiations open.
And today is the last opportunity to make a negotiated plea. Anything after the delay is going to be non-negotiated, regardless of whether the state or the defendant has negotiated something. We put this on a calendar a good while back. This case has been going on since God created Adam. And so if you haven't worked out something yet, too tough. We just moving it to the trial calendar. And that's all I've got to say. So you had plenty of time to talk about what could be done, and that's it. So further notice to the trial calendar, state's offer is withdrawn. Anything after this is non-negotiated.
That's fine, Judge. Thank you.
You're welcome. State versus Adams.
Mr. Adams, it's important to the whole providing us that I've never seen an offer in this case. Just yesterday, we're asking for a reasonable opportunity, so the way the offers are working.
We'll do a pretrial. Come back to you. All right.
Judge,
Yes.
can we make sure everyone is on the mic?
I'm sorry.
Can we make sure that all speakers are on the mic or at a mic?
Okay.
Please?
Were you able to get the last statements? Ms. Jones, were you able to get the last statements?
Yeah, she was very low, but I did hear her. I just
All
want to
right.
make sure.
All right, folks, court reporter is on the Zoom, and you'll need to be at a microphone that's actually working. I think that one might not have been working. Is it? All right. No, she got, Ms. Jones said it was difficult to hear, but she got it, so. All right, Damone Blaylock.
Good morning, Your Honor.
Good morning.
We received an offer from the state. I have reviewed that with Mr. Blaylock. At the moment, he would like to reject that offer, and we'd be asked to please be further noticed for a trial calendar. I'm sorry.
Go ahead.
There was one other thing that I wanted to just discuss with you. As I notified the court that I had filed a motion in reference to Mr. Blaylock's severance from the original trial. An order on that motion was filed on May 10th, if I'm not mistaken. I did request a hearing on that motion. I never received notice of that order until June 11th. I filed a motion requesting that the Honorable Court please reconsider that motion and allow me to be heard on that motion. There were some things that I did want to bring to the Honorable Court's attention to at least put on the record. So I would respectfully ask the Honorable Court if we could please set that for a date, and I could be heard on that motion. Yeah.
Okay, no. I decided it based on the brief. The defendant cited no authority for the proposition that the court was required to have a hearing on the motion. And so the facts and the circumstances that on the transcript from the proceeding were clear, and therefore there was no merit to going back to allow defense counsel to be able to orally argue a meritless motion. Second thing, we filed it in Odyssey, and from what I understand, your information is correct. So that's what we're supposed to do, file it, and it's supposed to go to council. Well, I don't know why you didn't get it, if in fact you didn't get it. But the more significant is the fact that Ms. Chavis, the case manager, emailed you a copy, and you didn't file a motion until 11 days or thereabouts after you actually clearly had notice of it because you got sent to you. And then the Superior Court rules, if you want to make a motion for reconsideration, you got to do it within 10 days. So even if you didn't get it under the normal Odyssey process, you had more than 10 days before you filed the response. So it was untimely. But, you know, this is, with apologies to the Four Tops, this is just the same old song. And it wasn't good the first time. So with no disrespect intended, I'm not going to just take up court time to allow somebody to come in to argue a case when the pleadings clearly make, and the facts aren't really in dispute. Therefore, that motion for reconsideration is denied.
Okay, Your Honor. I understand.
You further notice into the trial calendar, correct?
Yes, Your Honor. I just put just a few things on the record just for purposes of Mr. Blaylock.
Yeah, go ahead.
Just as it pertains to that motion, I did want to say, so again, that Mr. Blaylock did not consent to his severance originally.
Which is in the original brief.
Yes,
Go ahead.
correct. So generally, the trial court is allowed to sever an individual if, upon a motion by the defense or the state, that it could be granted on that basis. A motion to sever was heard on behalf of all the defendants in this case earlier, which was denied. On this particular day, neither Mr. Blaylock nor the state raised a motion. Both of us actually opposed. Mr. Blaylock and the state opposed that motion. There was no finding of manifest necessity by the court. There was no facts that the Honorable Judge Glanville laid out to indicate manifest necessity on this particular day. The only information that Judge Glanville put was that it served his best interest. To be quite frank, I'm pretty sure it would serve everyone's best interest to be severed in this case. However, there were no factual findings of manifest necessity, which is what is required for a trial judge to sever a defendant. There was no facts. There was nothing pertaining to the actual evidence in the case that was laid out as to justifying Mr. Blaylock's severance. It was simply that he fell ill one day. He wanted medical treatment. Mr. Blaylock and I offered to waive his presence, offered an alternative to being severed. The Honorable Court denied that and elected to sever him despite his discontent with that. And just ultimately, there were no factual findings. There were no findings based on the evidence being confusing, being prejudicial to Mr. Blaylock, and no finding of manifest necessity by the court justifying his severance without his consent. That's all I have to say on that, Your Honor.
Question, what, if anything, you just said now that you didn't put in the initial brief?
I put most of that in the initial brief. Just the reasons that people generally have motions. I'm sure that when we come in here and I'm able to orally express certain things to you, I'm sure that I can not only have a chance to respond to what the state says, but also I can answer any questions that you may have, frame things in a different way, rather than taking up paper, putting everything in a written brief. So that's really why I wanted to be heard, just to, really be able to flesh out some things and answer any questions that you may have. If the Honorable Court stands by his ruling, I completely understand and I respect that. But I did just at least want to be able to put some things on the record.
Okay, well, let the record reflect, you just argued the motion and you haven't said anything that's going to change the court's mind. And so the motion is denied. All right.
Okay, Your Honor. Thank you. May we be excused?
Yes, sir. You can. We've got so many defendants in here. We'll have to, in an orderly fashion, allow different defendants to be excused at the time that is most convenient and safe for the sheriff to handle that. So, but you may be excused. So have a good day.
You too, Your Honor.
I cannot be excused. I don't feel, you know what I'm saying? I turn that the other day, so I cannot be excused.
Who is your attorney, sir?
I don't need nobody to turn names, sir.
Oh, Mr. Lalum. Okay. All right. Yes, sir. I think we received an email from Mr. Lumumba, was it yesterday sometime or whatever, indicating that he had a family emergency and needed to be at the hospital with his father, was what we were told. I think the state was actually sent a copy of that email as well. Ms. Hilton?
Yes, Your Honor. It looks like, are you here?
I am, Your Honor. My name is Attorney Kareem Cashman. I've been the
Would you get on a microphone for us, sir? And would you come on, man. You know, I'm trying to do the best we can to, yeah. All right, that's fine. We will see what's what. All right. Yes, sir.
Good morning, Judge. As I was saying, my name is Attorney Kareem Cashman. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Cobb.
This is Mr. Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
Your Honor, it appears that Mr. Luemba is the attorney on position number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay, sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right. Your attorney that's assigned to you, now whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying, and you're indicating that you don't even know who they are, and I appreciate what you're saying, all right? He isn't here today, so we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is, that I never can get these initial kinds of things straight, but when a request is made for an attorney to be appointed to represent a defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. This case has been going on so long that certain defendants may have had one attorney, then somebody left the PD's office or somebody left the Georgia, whatever they call them, Council of Defense Lawyers or whatever it is. And then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So what we do is the best we can do. So if somebody hadn't had a chance to adequately prepare or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Now, whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today, his father apparently is in the hospital, and unless we've been told something that's not true, and I don't have any reason to believe it's not true. His father's in the hospital in a very serious situation, and he's there with his attorney there. We'll look further into the idea of whether or not he's adequately been prepared or been with you to do what he needs to do to represent you in this particular case. So that's the best I can tell you right now. Now, if you want to, you may want to hear what the rest of what's going on. If you would, you can stay. If you want to step out, then we can do that now if the sheriff is able to do that. Okay.
We just keep his final plea open, given that his counsel wasn't present today?
Yes.
Okay.
Let me see. Okay, next is State versus McMullen.
Morning, Judge.
Good morning. If you, yes, please.
Please.
Good morning, Judge. Attorney Lim here for Mr. McMullen. I don't have discovery yet. I am going to get it in different phases, but as soon as I get it, I'll do my best to get this case ready for trial.
You were just recently appointed.
Yes, Your Honor.
Did you not? Well, that's what I'm saying we're dealing with. Guess we'll hold this one open as well to allow. Let me see, what do we got for? Okay. All right, Mr. Lim. Then we'll leave it open and you can continue to come up to speed.
Yes, Your Honor. Might be excused.
Yes, sir.
Judge, can we get him to stay and spell his name for me, please?
Yes, M-E-N-G, last name L-I-M.